request Anirban to say a few things, his take on the amendments, and what does he think about how the amendments will address governance issues, if you have a view on that.
Good afternoon, everyone. Thanks, Samnath, for giving me this opportunity. I'm sorry, I couldn't be here for last 2 days as I was busy in a family function. I do not have a presentation with me because I was supposed to be in a roundtable discussion. So what I'm going to do is that I'm going to make a few points which I was thinking about the amendment. Now, if we are looking at the statute as a balancing mechanism between incentive and access, then it goes very close to the title of the seminar, that is this balance being right after the amendment. We did get photographs, copyright duration extended. We did get DRM protection. We also have the balancing mechanism through statutory licensing. But let me take few points which will be administratively, logistically, and administratively becoming difficult. If I take the point relating to the definition of commercial renting, the word non-profit purpose, how we are going to define that? Are you going to look at the composition of the audience? Are you going to look at the issue that whether are you collecting fees? Are you going to compare between the expenditure and the revenue earned? How you are going to decide non-profit purpose? The second point, about the definition of performer in the proviso, you have a word, phrase called normal course of practice in the industry. Now, what will be that normal course of practice in the industry? What are the indicator and what are the criteria to decide what is the normal course of practice in the industry? Let me take a situation which is in the industry. It's good that now authors are getting the royalty, shared royalty. My point will be that whether it also includes, say, scriptwriter or screenplay writer, if you are talking about the literary and the musical work. And then the other component of sharing royalty, which has just now been discussed, that how it is difficult logistically, because how do you know that, how are you going to make sure that you are going to divide and share royalty equally? On the top of that, there will be a possibility the producer will keep their margin intact and put the pressure on the distributor so that they know that they have to share it with the lyricist and the composer. If you look at the entire amendment, then is this something towards the encouragement of learning borrowed from Statute of N, or is this a mechanism of ensuring a balancing mechanism? And these few things which or few expressions which are used will be definitely will require certain support from the commentators, from the judiciary, that how you are going to define these expressions. On moral right, is it that you have now removed that requirement that that even if the mutation modification happens after the expiry of copyright, you will get more right protection? Good. But if you have a law on defamation, do you really need that? Or was that really required? The last point which I'll like to make is that in case of performer's right, whether in the same way as you have done with the author's moral right, can it be claimed by the legal representative in case of performer's moral right? I understand that it's at the end of 2 days seminar, so, and I was preparing for a group discussion or a roundtable discussion, so I stopped there, and if I can contribute by any questions or anything, I'll be glad. Thank you very much.
Any questions for Dr. Mazumdar? Yeah, Shamad has a question, and there's one friend of mine who's sitting in the last row. Yeah, there he is. He has a question for I think we are all ears for your suggestion.
Sir, you are saying that the counting has become more complex with everyone's rights as per the copyright amendment. I have a little experience with accounting. In class 12th and I was a commerce student. So when the amount becomes too less, the only way to let everyone get their own penny is that you, after 1 month, the total should be divided amongst the shareholding percentage that each one has. Therefore, prior to the release of the music, maybe only one song, each song should have a specific share purchase agreement. So if you have a specific share purchase agreement, in my reading of the law, which is very little, is that everyone will get their own specified money. At the end of the month, the song might be just 11 paisa per person per use. But at the end of the month, you'll be able to account for it. My second suggestion is to the lady who was representing FICCI. Now, and she's not here, sir. Is that how to curb piracy? And correctly pointed out by Mr. Sinha, it is because the cost of the movie that we see. Mr. Sinha, the same movie I can see for 90. And in Delhi it will be about 300. That means the real price of the movie nobody actually knows. I have seen for 90 rupees on first show, Dark Knight. It's not an Indian publisher's movie. It's a producer from outside for sure. So therefore, my humble suggestion is that the movies have prices and multiplexes have to be regulated so that everyone can affordably see. There requires to be a regulatory authority of pricing for multiplexes in the entertainment industry. Secondly, sir, if the movie theaters and the physical point has been pointed out that a person who's from the backward society of India feels absurd to enter a movie hall in a multiplex, and therefore piracy will still permeate. My suggestion is that each of these producers have their own websites. So after 4 weeks of the movie being released, if they on their own very website allow you to see the movie at an affordable price by paying them directly by PayPal, Visa, Master Secure Code, I think that the producers will get their right amount of money. Only thing, yes, after the 4 weeks, the multiplexes will lose. But in generation of copyright industry, in entertainment industry growing in India, I think so it will ultimately benefit the taxation exchequer and the producer, who feels that he's losing. Yeah.
Okay. Thanks a lot. I would exercise the right of the chair to not allow any answers right now, because you said that there were suggestions. Okay, because otherwise you will be minus the chair. I'll have to leave. I have to catch my flight. So let me just wind up this session by saying, this was the last technical session of the conference. Let me just wind up by saying, there will always be glitches. It will not be a perfect law. If it were to be a perfect law, then perhaps a litigant would not require the Kala Court Walas. They'll go and argue before it will be absolutely cut and dried. It will not be a perfect law. It is not a perfect law. But having said that, despite the problems that Anand has pointed out, and the issues that Praveen Anand had also pointed out, and throughout the sessions, people have been talking about the infirmities of some missed opportunities. This law is a quantum leap from 1999. It's been 13 years in the making. It has covered substantial ground which was at one time never thought would be covered. From a 30-member core group which never met, or which met, then you would have all the lawyers articulating their client's interest. So Microsoft was present in that core group by not being present. Okay. And similarly, there were other such clients who were being represented by not being present. From that 30-member group, we came down to a 3-member drafting committee, and then from 3-member drafting committee, actually it turned out to be a 2-member drafting committee, which worked very secretively over a long weekend, not revealing to their families where they were, in that kind of secrecy. And we came up with a draft that was finally put up on the website, and then it went through iterations. And from 2006, after it was put up on the website, and the first draft of the amendments was put into circulation between the ministries. To 2012, bulk of the work has been done by the gentleman sitting there. He does not admit to having seen any pirated movies or listened to any pirated music. I don't believe him. But let me tell you, what you need to believe is that if Raghavinder had not been there, it is his diligence, it is his hard work, it is his commitment. Then what Professor Gopalakrishnan had been talking about, the lobbying, that lobbying could have overridden a lot of the gains that have now been made in these amendments. So let me ask you, in all fairness, to give a round of applause for this gentleman. And then we needed to thank, but they are too numerous to be thanked. So what we would say, we also need to have a round of applause for Professor Gopalakrishnan. He talked about the lobbying, but it also is an epitome of how honesty of purpose can thwart any kind of dishonest lobbying. And despite the principal director not being there, despite the exhaustion of rights clause not being there in the form that would have, I mean, to most people it would have made sense. Despite not being there, we look at so many other things that are there, and we say, okay, fine, in all due respect to everyone, we have done something. Let us see how it pans out over the next half a decade or maybe a decade. And then we come back and then we re-examine it, and when we see maybe a few course corrections along the way. So we have, with this we end this session. Thank you very much. Thanks to my two colleagues who are eager to see me off now. Thank you very much.
Thank you. So we're not so eager to see you off. Please don't say that.